Thank you. Please take a seat.
Thank you. Doctor, I'd like to look now at the case of D1527 that I know you've looked at in some detail as a case study. When D1527 arrived in Brook House on the 4th of April 2017, he was already on an ACCT document from HMP Belmarsh, is that right?
Yes.
Essentially the document that the ACDT system is derived from.
Yes, as I understand it, yes.
That prompted the commencement of the ACDT process within Brook House on that day. Although D1527 was seen by Dr. Chowdhury on the 5th of April, he doesn't appear to have been provided with a Rule 35-2 report on that occasion, notifying the Home Office of his history of self-harm and suicidal ideation. And you say in your report that given that D1527 was on an ACDT, in your view, he should have been provided with a Rule 35-2 report on that occasion, is that right?
Yes.
Or indeed, if not a Rule 35-2, then a Rule 35-1 report, because being on an ACDT with a history of self-harm and suicidal ideation indicated he was likely to be injuriously affected by detention, is that right?
That's my view, yes.
9 days later, on the 13th of April 2017, a Rule 35-3 report was completed by Dr. Uzarali, and that referred to the fact that he was on an ACDT at the time of the assessment, but he didn't then do a report under either Rule 35-1 or Rule 35-2. Should he have done?
Yes, in my view, it should have been done.
So simply because a Rule 35-3 report had been done didn't obviate the need for a report under either of the other two limbs.
Not in my view and not in my understanding of the rules.
And should even the Rule 35-3 report have occurred earlier than 9 days after he'd been received into detention?
I think ultimately, yes, it should have done, because if the detained person had declared a history of torture at the Rule 34 appointment, had that been in place, then arguably the Rule 35-3 would have been done at that time, rather than potentially at a later stage or a delayed stage as a consequence of it apparently being picked up by another member of the team, and I can't remember without the records in front of me at what stage that was then picked up for that Rule 35-3 appointment to have happened.
Yes, but certainly not on his arrival or within 24 hours of on his...
It didn't happen, no.
The Rule 35-3 report, as I said, was done on the 13th of April. The response from the Home Office on the 18th of April concluded that detention would be maintained on the basis that the negative immigration factors outweighed the level of D1527's vulnerability. The records then show that he remained on an ACDT document and was subsequently apparently refusing food. He then self-harmed by making cuts to his wrist on the 24th of April 2017. And these, you say in your report, these additional factors in D1527's case were not apparently relayed to the Home Office through the use of Rule 35-1 or Rule 35-2 in a report. Is that right?
That's right.
And they should have been at that stage, shouldn't they?
Yes.
Under either one or both of those limbs of the rule.
And yes, absolutely, yep.
On the following day, the 25th of April 2017, D1527 was subjected to a use of force when he attempted to ligature and swallow a battery. And we know he was moved to E-Wing for closer observation. We'll come to the incident on the 25th of April in more detail in a moment, but you say that thereafter on the 26th of April he was seen by Dr. Uzarali on E-Wing, and there's an entry in the records to that effect. Despite the events of the previous day and the subsequent move to E-Wing, again, no Rule 35-1 report was completed and no Rule 35-2 report was completed. Either one or both of those should have been, shouldn't they?
Indeed, yes.
At that stage. If not on the 25th by a referral by the nurse involved in the incident immediately to a doctor on that day, then at least by Dr. Usarali on the 26th of April.
Yes, yes.
Excuse me. The System 1 records, the medical records, show that following this incident, he was continued to be observed on an ACDT document and continued to refuse food. But despite that ongoing deterioration in his presentation, again, there was still no Rule 35.1 report provided to the Home Office. The continued refusal of food should have prompted further inquiry and consideration of a Rule 35.1 report, in your view.
Yes.
Again, all of those incidents and the case as a whole is another illustration of various systemic failures in the safeguards at each stage. Is that right?
It is, yes.
And we've covered the general ways in which the case studies illustrate systemic failures. I just want to ask some further questions about your view on the particular case in relation to D1527 before coming to the incident. In your supplementary report at paragraph 3.3, you state that you stand by your opinion that the deficiencies you've identified in your original report, and we've been through in some considerable detail this morning, did not directly result in the mistreatment of detained persons. And I just wanted to ask you, having considered all of the evidence that you've now seen since completing your reports, including the live evidence you viewed to the inquiry, has your view on that issue changed at all?
Well, I suppose it depends what one means by direct or indirect, and I think there are multiple layers to this. I mean, there's no evidence to say that a doctor or nurse went and directly did harm to an individual, but neither did they take care of the responsibility of the duty of care in an active way. So I would say that that's an indirect means. That
yes.
In other words, they didn't take responsibility for all of those steps and recognise the impact of the failings of taking those steps on what that might lead to. So that's my view on why it's an indirect, because they didn't directly cause the harm themselves. But
yes,
there's no doubt that two things are linked.
Yes, and so it was through inaction rather than positive
Correct.
action,
Yes.
in other words.
Yes.
Because in respect of this particular detainee, D1527, it's clear from the footage that Mr. Tully recorded that staff didn't understand his mental health problems. They weren't concerned about his welfare as such. They were rather frustrated by the presentation of his symptoms. Would you agree?
Absolutely.
And that's further demonstrated by the derogatory remarks that we hear from both detention and healthcare staff in relation to him, isn't it?
It is.
And so, at least to that extent, you'd agree that D1527's, had his difficulties been identified and treated appropriately, he might have avoided that ill treatment.
He might have done, but I think generally from my view of all of the material that's been provided, I think there's also the cultural aspect of it in terms of how you approach this sort of complexity, and I think that was also lacking.
Yes, another failure.
Yes. Yeah.
And that indicates a link, at least, between a systemic failure to diagnose, manage and treat mental health difficulties and ill treatment by staff, doesn't it?
Yes.
Yeah. Including clearly the failure to complete Rule 35.2 or indeed 1 reports despite his suicidal ideation and episodes of self-harm.
Yes.
Which led to force being used upon him.
Yes.
By Jan Pashali and his colleagues in the manner we see on the footage.
Indeed, and I think the issue here is that, again, it feels a little bit like the discussion we had earlier around Rule 40 and removal to segregation. It almost feels like that was the thing to do at the time because there were no other options.
And so the thing to do was to use force.
Use force.
And it clearly went far too far in this
Yeah.
particular incident.
Absolutely, yes.
I just want to deal then with the healthcare aspect to the particular incident with Jan Pashali as it relates to as she then was Nurse Jo Buss. And there are several aspects to it. So the first is in relation to inappropriate comments. When detention staff that we see on the footage made comments about him, and sometimes in his presence, that he was a cock, a tool, a Duracell bunny, an idiot, a baby, those types of remarks that we've all seen and heard, Ms. Buss should have challenged them directly, shouldn't she, at the time?
Yes.
She should have reported them as well, shouldn't she?
Yes.
To her line management, or theirs, or both?
I suppose it depends what the line management would have done about it, but arguably just to leave it go unchecked again is a failure in its own right.
Yes. And she clearly...
And to be complicit with it.
Yes, absolutely. And clearly, as she's accepted, she shouldn't have made the comment, he's an arse, either. We all agree that's inappropriate.
Yes.
And derogatory.
And derogatory, yes.
So moving on to the incident itself then, in relation to the use of force, and in particular what we've all seen Jan Pashali's role was in that. It's quite clear that if Jo Buss had seen what Jan Pashali did with his hands around D1527's neck, the so-called choke hold, she should immediately have told him to stop, shouldn't she?
Absolutely, yes.
Likewise, if she heard him say he was going to put him to fucking sleep, she should immediately have challenged Mr.
Yes.
Pashali again.
Yep.
Because that's a direct threat, isn't it?
Yes.
And would have been perceived as such by D1527 at the time, you would imagine.
Absolutely, yes, yes.
And she had a duty to intervene in the circumstances.
Yes, she did.
At the time, immediately.
Yes.
If she had heard Callum say, Jan, easy, easy, as again we've heard on the footage, that should have caused her a concern, and again she should have intervened or inquired further as to what was happening, shouldn't she? To ensure D1527's welfare.
Yes, and so no doubt you may be coming on to this, but from what appears to be from where she was standing and her inability to see what was going on, arguably intervening should have been at the forefront of her mind preemptively in regard to some of the things that you've just set out, or
Yes.
at least to have been able to have seen what was going on.
Yes, we'll come to that, as you say, in a little more detail in a moment. If she had heard D1527 say my neck, which he is heard to say 5 times on the footage, on any one of those occasions, and indeed on all of them, had she heard them, she should again have raised a concern as to what was happening with his neck, given he was under restraint at the time.
Yes.
And she should at least have inquired what was happening, both of staff and of him, shouldn't she?
I would say more than inquired, because
Yeah.
given the complexity of what was physically happening in that situation, it was her duty to get amongst it and see what was going on and to take the relevant actions and the relevant steps at the relevant points,
Yes.
rather than to be a passenger in the situation.
Yes. Ms. Buss gave evidence that she hadn't seen or heard those things I've just described, contrary to her admissions in her NMC disciplinary proceedings, because if she had, she said she would have intervened. Whether she did or not is clearly a matter for the chair to consider in due course, but I want to ask you, as you've anticipated, some questions based upon her current account, that she couldn't and didn't see those things, and she couldn't and didn't hear those things. We've already considered the important monitoring role that healthcare staff who attend a use of force hold. That's an important safeguarding role, isn't it?
Yes, it is.
She accepted in her evidence that she was carrying out and had a duty to carry out that role to safeguard D1527 safety and welfare, and you're in full agreement with that.
I'm in agreement that she had a duty to do that. I'm not in agreement with her actually doing it.
Yes, absolutely. She said she was monitoring him visually. She had an obligation, didn't she, to put herself into a position to be able to see and hear what was going on in this restraint.
Yes, she did.
She accepted that it was particularly important to be able to see his face and neck in order to monitor his breathing, to check that there was no obstruction to his airway, and to monitor his level of distress. Do you agree with that?
Yes, I do.
As we now know, it was also important to be able to see that he was being choked.
Indeed.
But if, as she now says, she couldn't see his face and neck, and that monitoring, then that monitoring wasn't being carried out adequately, was it?
No, it was not.
Or indeed at all.
Indeed.
She had a duty, if she couldn't see and hear, to do one of several different things, didn't she? She could have, for example, put herself physically in a position to be able to see and hear, couldn't she?
At least to try, or to make it clear that she was wanting to do that, or to try and do that, to let the officers know that that was her intention. I can't see. I need to see what's going on.
Indeed. And if that wasn't possible for some reason, as
Yep.
she seemed to suggest to some extent in her evidence, then her duty was to raise a concern with the detention staff that she couldn't see and couldn't
Yes.
hear, so she couldn't monitor his welfare in the restraint.
Yes.
That's right, isn't it?
Indeed it is. Yeah.
And she didn't do that.
No.
A third option would be simply to stop the restraint, wouldn't it? To
Indeed,
say,
yes.
hands off, I can't see and I can't hear.
Yes.
She didn't do any of those things. Had she been adequately safeguarding his welfare in those circumstances?
Say that again, sorry.
She didn't do any of those
She
things.
did not do any of those things.
Was she
that-
adequately safeguarding his welfare in
No.
those circumstances?
No.
Her actions, or at least her inactions, exposed him to further mistreatment, didn't they?
Yes, it did.
I just then want to very briefly look at three short pieces of footage. Could we have Kentkov 1007, V number 2017 04254021, please, at 7 minutes or thereabouts, 7 and 5 seconds to 8:25, please, minutes. So can we go back and have sound? That would be great. Do we need to get the... Yes, but I wonder if we could just take a couple of minutes. It seems to be a problem with the sound. If we could just inquire and try to fix it.
Of course, yeah. Do we want to pause for a few minutes?
Yes.
Would you like me to pause for a few minutes? Yeah,
That
sure.
would be great.
Okay,
Thank you. Sorry about that.
No problem, thank you.
You're right. What happened?
Live, please.
What are you doing? Stop it. Stop. Mate, don't do that. Don't do that. Don't do that. Give us a hand. Guys, please. Give us a hand. Stop. Get your hands off. Don't do that, mate. Don't do it, mate. Don't do it, mate. Don't do it, mate. Don't do it. Don't do it, mate. Don't do it. Don't do it, mate. Stop. 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 They really needs to be locked down. Open the window. Show me the office. Show me the office. He's on the back door. No, he didn't. Sorry? I don't think he had anything with him. We couldn't really see. I was talking in. I don't know. Yeah. I couldn't see. I literally just went to look at him then and he was doing it. Nathan just asked me to come in and look. Relax, relax. Relax.
If you could just play maybe just 5 more seconds, that would be...
Relax.
Thank you. Nurse Joe Bus would have heard the sound that D1527 was making here during this chokehold, as it's been described, incident. Whether we call the noise he's making choking or some other description, should that noise that he's making that we hear in that footage just there, particularly towards the end, have prompted a concern on her part, in your view?
If indeed she was standing within hearing shot of that, and I'm not sure precisely in my mind where she is at this point.
If she heard that, she should have raised a concern at that stage. Yes. She accepted that she could see 4 people restraining him on the floor, in the general sense of she sees that there are 4 people there and the restraint is happening on the floor. She described them as physically struggling. She didn't intervene during any of that process. Was there a point she should have intervened, or at least raised a concern, even had she not seen or heard that precise...
I think, as you say, the noises of the apparent inability to breathe should have stimulated some action. Certainly, what appears to be very audible words from Jan Pashali's mouth about intending to put him to fucking sleep should have absolutely raised a concern.
If we can just play on from there to 10 minutes, then please. Thank you.
Jan, easy. Is this one of the back? No, it's there. Where? It's there. It's over there. Right. It's got a battery. Right. Right, you're going to stop being a tool now, yeah? You're going to stop being an idiot. Yes or no? Yes or no? Yes or no? Right. Right, you're going to stop being a tool. Yes? Yes or no? Right, now listen. Right, we're going to release you, and then you're going to speak to healthcare. You understand? Do you understand? Yes or no? Yes or no? Ready? Ready? Silence. Yes, ready, cover position. Ready? Over to you.
Why is he out of his cell?
Thank you. At the beginning of that clip, at around 8:38 to 8:42 seconds, Nurse Jo Bus accepts that the person whose feet you can see on the right-hand side of the screen to Jan Pashali's left was her.
Yep.
So she was certainly present right beside D1527 and Jan Pashali at that stage of the clip and would have remained in the vicinity thereafter. Are the noises that he's heard to be making at the beginning of that clip of concern?
Yes, they are, yes.
And she should have intervened at that stage.
Absolutely.
Towards the end of the clip there, from somewhere around 9:30 minutes to 10 minutes, the last 30 seconds of the clip, D1527 is forcibly put into the recovery position by the detention staff, and we can hear on the footage the noises he's making at that stage. Ms. Buss accepted that he was in very severe distress at this point and that it was obvious he was mentally unwell. Would you agree?
Certainly highly agitated, did not have a normal respiratory rate and wasn't, making those noises for no other reason.
Yes.
Yes.
She should have intervened certainly at that stage and raised a concern, shouldn't she?
I think at the latter point it was probably too late, but certainly to attend to essentially her patient in some way, in a supportive manner, would have been what I would have expected.
Yes. If we play then, please, can we move on to 12 minutes, please, and play just for 30 seconds or so? Thank you. We can see Nurse Jo Bus in the picture, can't we? And we can see that Charlie Francis, the person physically on D1527, is still applying restraint on the floor, isn't he?
Yes.
And that's what we can see in the footage. Nurse Bus, Jo Bus accepted that she could see and hear D1527 at this point, as of course is obvious from the footage. Should she have been concerned, raised a concern and intervened at this stage?
As I say, it's hard to understand what Charlie Francis is actually doing in terms of restraint at that point, but to show some level of concern for the welfare of the detained person who's lying on the floor in a very distressed state might have been the appropriate thing to do in this situation. But I don't see anything other than what appears to be disdain.
Yes, her being a bit fed up, head in hands.
Yeah, it doesn't. I can't rationalise that approach to my mind, and intervening in terms of some other action, i.e., to push Charlie Francis off or tell him to stop. I'm not sure from what she can see how she would intervene other than to say, look, can we, give them some breathing space?
Yeah, to stop the restraint.
Yes,
I think we should stop now.
Yeah.
Yes. After the incident, thank you, you can take that down. After the incident, there was a conversation between Callum Tully and Jo Bus concerning the use of force form, the documentation, in which she accepted that she understood from Callum Tully that the use of force form, the documentation that the detention staff were required to fill in, wasn't going to be recorded. And it wasn't going to be recorded, therefore, as a restraint at that time. She should have challenged that, shouldn't she?
Absolutely.
With them immediately at the time, you need to fill in the form.
Yes.
And indeed, she should have reported it to her line management, their line management, or both.
Yes, it should have been recorded. That's non-negotiable.
And not just that the healthcare section of the documentation that she's responsible for, but in understanding, as she did, that the detention staff weren't going to fill in their side of the documentation, she should have challenged them in that and reported that up up the line management.
Yes.
If we look then at the documentation, the ACDT document has an entry from Joe Buss in it. If we look at, please, CPS 509 at page 8, please. The second entry down, Dr. DUC, says it's at 25th of April. There's one at 1901 and then there's one at 1940. Do you see that?
Yep.
And it says seen in room 7, the one at 1940, seen in room 7, constant watch. D1527 had tied a T-shirt around his neck, angry, upset, had mobile phone battery in his mouth, attempted to self-strangulate in the toilet, visual observations only due to demeanour, resps of 16, so respiratory rate of 16. Is that right?
Yeah.
That's the extent of the documentation by Joe Buss in that document. In your view, does that entry accurately convey the nature of D1527's presentation and the restraint on him, even on the basis that she hadn't seen the chokehold?
Not remotely.
It's not adequate, is it?
Not adequate at all.
He was certainly more than angry and upset. Would you agree?
Yeah, it's deficient in a number of areas. It doesn't go in any detail to the length of the incident,
The severity of it.
The severity of it. Respiratory rate of 16, it's clearly not a respiratory rate of 16. We can hear it at the end, and in fact, even at that point, before he's rolled into the recovery position, his respiratory rate is, it's certainly well above 16. 16 is a normal resting respiratory rate. He was not normal and resting and breathing at a normal respiratory rate at that point when he was being restrained on the floor.
And even if he ended up later, under her observation, as a respiratory rate of 16, this entry in no way records, in several respects, the true nature of what we see on the footage, does it?
And it fails to mention that use of force was required.
Yes. If we look then at the medical records entry, can we see, please, CJS 001002 at page 38, please? And if we go down, please, to 1851, yes, there we go. This is the entry that Joe Buss made after the incident in the clinical record. And we see there it says examination placed on Rule 40, constant supervision as he refused to return to E-Wing, called to E-Wing at approximately 1900, constant watch, had placed a ligature around his neck, removed by staff trying to engage with him. RMN Dahlia tried to engage with him with minimal effect. Put mobile phone battery in his mouth, which he later removed, battery removed from his room. Went to toilet and attempted to self-strangulate. Angry and not engaging with staff. Hands removed from his neck by staff. Salivating ++. Unable to take any observations. Visual obs, resp 16. Slight redness noted on his neck. 2000, got up and walked around room. Taken a small drink. Restless. Constant watch continues. Not engaging with staff. Plan, please review later this evening. There's no mention in that entry of a restraint or a use of force at all, is there?
No.
There should have been, shouldn't there?
Yes.
Had placed a ligature around his neck removed by staff, clearly doesn't adequately record the use of force upon D1527, even leaving aside if she had seen the chokehold or not.
Indeed it doesn't.
It doesn't accurately convey the totality of the nature of the incident, does it?
Not even remotely.
Nor the nature of his underlying clinical presentation, his severe distress, the fact he seems to be mentally unwell.
It doesn't.
Angry and not engaging with staff doesn't begin to describe his mental health presentation.
No, and it feels somewhat blaming
Yes,
of the detained person for the incident.
Yes. It certainly doesn't describe his level of distress.
No.
We know that he's a person who has had post-traumatic stress disorder. Would he likely have been very frightened by this incident?
Who wouldn't be?
Yes. It would have been perceived as an extremely threatening situation by him.
I can't imagine it.
Yes.
I've not been through something like that, but the mind boggles.
Yes, and this type of terminology, as you say, rather blaming of the detained person themselves, that really misses the more clinical observations that you would expect clinically trained staff, such as a senior nurse, to have been able to make in this record about the levels of his anxiety, his distress and his mental health symptoms, doesn't it?
Yes.
If we can look then at the last piece of documentation in relation to this at CJS 005534 at page 10, please. So this is the use of force form. This page is the page in relation to the incident in relation to a report of injury to detainee. This section is blank because this is the section that should have been filled in by detention staff. If we go over the page to page 11, please. This is the entry that was made by Nurse Mariola Makuka. Nurse Buss said on her instruction and on her behalf. And we see there the time and date of the examination as recorded as the 25th of April 17 at 1900, and the report is seen on E-Wing, room 7 by RGN Joe. Detainee had placed a ligature around his neck, removed by staff. After this he went to toilet and attempt to self-strangulate, hands removed from his neck, slight redness noted on his neck, and the body map is filled in with slight redness on his neck. Do you see that?
Yes.
Given that this is recorded in a use of force form, we can at least understand that some force was used upon D1527 during this incident, can't we?
And that an injury had been sustained.
Yes, the redness to his neck,
Yeah.
Indeed. But again, does this brief note in any way convey the seriousness of the incident we see on the footage?
No, it doesn't, and the additional concern is that it's not completed by the person who was there, so how could it possibly be completed accurately, unless it was dictated, in which case, why didn't she write it herself?
Yes. So, in considering the totality of the documentation, those 3 entries we've just been through, that doesn't meet the standards required of a nurse in terms of filling in documentation, does it?
No, it doesn't.
Had we not got the footage, we would not be able to have, and neither would anyone coming after this incident, reviewing these documents, have any appreciation at all the true nature and seriousness of this incident, would we?
I agree.
Completely unacceptable.
Completely unacceptable.
And a failure in her safeguarding role.
And it opens the question as to how many other times this has happened unchecked.
Absolutely. You can take that down, thank you. D1527's case is an example of a resort quickly to a use of force as a response to an incident of self-harm that seemed to be quite widespread in Brook House. Would you agree?
It appears to be, yes. As I say, it seems to be the sort of the go-to option.
Yes. Certainly not used as a last resort.
No.
And certainly not used only in the immediate life-saving sense.
I think in this case, there clearly appeared to be a ligature around the neck, so I can understand the need to intervene for life-saving.
But once the ligature is removed...
But once the ligature is removed, and that appeared to happen relatively quickly,
Yes.
that the incident therefore should stand down or be withdrawn so that there's no longer any further restraint or, just involvement with the detained person, give them the space to breathe and to come to terms with what's been happening,
Yes.
rather than persisting with it.
Yes. There's
Which seems to have been intentional in terms of some form of reciprocation, some form of punishment.
Yes. There was no corresponding consideration of Rule 35, as we've established,
No,
or to any other clinical interventions at all from the records.
not that I can see.
That remains of considerable concern even today, doesn't it? If that's a continuing resort quickly to use of force in the absence of Rule 35 reports and in the absence of other clinical or therapeutic interventions.
And additionally left unanchored in the medical records, please review later, doesn't equally go as far as I would expect it to in terms of a clinical handover, both in terms of what's documented there, but also in terms of what would need to happen outside of that in order to ensure that staff, healthcare staff, were following up,
Yes.
following on from an incident like that.
We know that the most recent IMB report recorded that 37% of use of force incidents were as a response to self-harm. That's of considerable concern in and of itself if those are the types of numbers we're seeing in terms of use of force as a response to self-harm. Would you agree?
Yes.
Again, in relation to use of force, you make a recommendation that there clearly needs to be a more robust approach to the system of education and training for both custodial and healthcare staff. And ideally, you say in relation to use of force, training provided should involve the opportunity to train both custodial and healthcare staff alongside one another.
Yeah.
And that you say this will help to ensure a cooperative and collaborative approach is developed between the two elements who owe a duty of care to the detained persons within Brook House and a better understanding of each other's roles and responsibilities. In your view, was there clearly a lack of understanding of the roles and responsibilities of the other type of staff?
Yes, I think so, yes. I mean, it appeared that the custodial staff, or one particular member, was acting essentially with impunity. I can conduct myself how I please, knowing that I'm not going to be challenged
Yes, and clearly
by the
healthcare.
countering, by the healthcare side, let alone by the other custodial officers.
Yes. Better training and a more robust approach would ensure that healthcare staff have a better understanding of their own role in regard to the recognition of any poor practices or ill treatment by detention staff. Is that your view as well?
It is, but I think the point I'd also like to make is that we should be looking at means to reduce the use of force as much as possible, and
Yes.
it is a last resort. So I wouldn't want the use of force to become as resorted to as regularly as it appears to have been, and that training is there to support that ongoing use of force, if you see
Yes.
what I mean. It's more to make sure that when it does happen, and hopefully less frequently, that it is conducted correctly.
And that the healthcare staff truly understand their
yes.
safeguarding and monitoring role
Yes,
and actually carry it out.
yes.
I'd like to move on then to D643. D643 was a combat veteran who served in the British Army in Iraq and Afghanistan, and he'd been diagnosed with PTSD prior to entering immigration detention, and an entry in his prison records confirmed that. He was detained on 4 separate occasions in June and July 2016 for 24 days, in August 2016 for 7 days, in October and November 2016 for 23 days, and then finally between the 21st of December 2016 and the 8th of May 2018 for 504 days. By the time of his 4th time in Brook House, that last occasion when he arrived on the 21st of December 2016, he'd been through 3 separate health induction assessments, the screening process, but the medical assessment on his last occasion didn't mention a history of PTSD or of previous suicidal ideation. Does that indicate both a systemic failure in the screening and the application of the Rules 34 and 35 process?
Yes, it does.
is it indicative of a lack of a system to identify and cross-refer to previous medical history?
At least, yes.
And that's potentially harmful in individual cases.
Yes.
D643 spoke fluent English. He'd served in the British military and he had experience of obtaining PTSD treatment both in prison and in the community.
Yep.
He says that he asked on several occasions for help whilst in Brook House. The extent of the help he was offered was attendance at an emotional health group, which inevitably couldn't focus on his PTSD, and he said he didn't find helpful. He says he was promised a referral to a psychiatrist, but that never happened. This is another example of an underlying condition, PTSD, not being identified in Brook House, and so it couldn't be and wasn't treated. Is that right?
Certainly wasn't considered in that way, no.
It ought to have been identified and clear from the outset, oughtn't it, given it was in his medical records?
Yes. Yeah.
If someone in D643's position couldn't get the help he required despite speaking English fluently and being able to identify precisely what he required, treatment for PTSD, does that indicate that it would have been even more difficult for others not in that position to do so?
Yes, absolutely. Yep.
It might be practically impossible with limited English, with limited knowledge, or with limited insight into your own condition due to an experience of trauma to access anything, might it?
Yeah, need of interpreters, all of these things have a potential resource implication which don't appear to be used systematically in order to go to the full depth that was required.
In your supplementary report at page 64, you mentioned the lack of time limit in immigration detention and the effect that might have on detainees. On the fourth occasion, D643 was detained at Brook House for a total of 504 days, notwithstanding his diagnosis of PTSD and the lack of treatment offered to him. Is it inevitable that a detention of that length in an environment like Brook House of a person with those vulnerabilities would lead to harm coming to him?
I can't see any other way, and I think even somebody without those underlying issues would find it difficult and would deteriorate in an environment like that.
Yes. In his case, does it indicate a complete failure of the systems designed to protect vulnerable detainees?
Yes.
A case progression panel on the 21st of November 2017 reviewed his case but recommended continued detention without any mention of his mental health. Does that indicate a lack of coordination between detention reviewing staff and healthcare?
Yes.
D643 says that he either informed healthcare that he was feeling suicidal or was identified as having suicidal ideation on at least 4 separate occasions whilst he was in Brook House. And on at least 4 other occasions, he says it should have been clear to the healthcare team that he was presenting with symptoms consistent with suicidal ideation or intentions. He certainly described having flashbacks, crying, isolating himself away from others. He said he felt depressed, anxious, and was struggling mentally. Should all of that have prompted a Rule 35(1) report to be produced?
Even in the absence of a specific diagnosis of PTSD being made, then yes, I think it should.
Should it also have prompted a Rule 35(2) report if he was expressing suicidal thoughts or ideation?
Yes.
You say in your supplementary report again that the mechanism for the generation of a Rule 35(2) report in response to suicidal ideation does not appear to have been working effectively in Brook House. But his experience, together with that of D801, D687, D1527 and D1914, appears at least as consistent with a complete systemic failure, doesn't it?
Yeah, it does. It wasn't happening at all.
And of course, we know in the light of no Rule 35.2 reports ever being completed in 2017, that indicates a complete systemic failure.
Yes.
In the context of a self-evidently life-threatening scenario, a suicidal risk.
Yes.
In terms of healthcare management from day to day, does that also, do those case studies and the evidence we have about them also suggest inadequate management of staff, given their failure to fulfil their obligations under the rules, and a resort to potentially harmful practices such as the use of segregation and sanctioning the use of force?
There certainly didn't appear to be an appropriate mechanism for ensuring that those checks and balances were being used in the correct manner. And I don't know whether that was down to a lack of inattention generally, or whether it was an additional frustration with the system, but it wasn't happening and should have been happening.
Yes.
So you would expect that the members of the clinical team working underneath the head of healthcare would have, felt it important to be checked in terms of the management of their head of healthcare, that these things were happening, and where there was any doubt, they should, rightly ask the head of healthcare what should be happening.
Yes. So had there been adequate day-to-day management of healthcare staff, you would have expected those safeguards to have been operating effectively.
Yes.
And the fact that they weren't suggests that there was inadequate management of the staff and their obligations under the rules.
In relation to those components of the healthcare, yes.
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 And that exposed vulnerable detainees at risk of harm to further harm because they weren't being notified to the Home Office for their detention to be reviewed.
Yes.
So in terms of the way the system was structured, whether it was to do with the resources available to those safeguards or the management of the staff or of Home Office oversight or lack thereof, the system was effectively structured and operated in a way that could lead to abuse and ill treatment, wasn't it?
Yes, so I think where I've said in my report that the healthcare was, I think in my original report where I said that it appeared that the healthcare was adequate, I'm referring specifically to the physical healthcare. What I've come to the understanding of is that the protective mechanism that sits around that core is what is inadequate, and I agree with what you've said there, that in the absence of any systematic protection around that, these failings have been able to arise as a consequence of that.
Yes, and they've led to the abuse and ill treatment of detainees, in particular in the cases that we've just been through in some detail.
And they certainly haven't protected them from other people.
Clearly that abuse and ill treatment's not limited to derogatory comments or physical harm. It clearly relates to mental health as well.
Yes.
You made some recommendations in your original report at 6.5.6. You said the system for the use of Rule 35 appears to be time-consuming, complicated and inefficient. The whole process for Rule 35 would benefit from a review in order to establish a more dynamic and efficient approach to detain persons considered to be at risk. Any subsequent development of a new process would require a systematic approach to the education and training in its use. Do you still hold that view?
Yes, I would add to that the understanding component of it, because as I say, the more that I've listened to the evidence and looked at the witness statements, it's clear that very few people who are delivering these, apparently supposed to be responsible for delivering these healthcare these responsibilities, don't understand the foundations as to why they're doing them.
Yes, and their role within them.
And their role within them, yes.
You say at 6.5.7, the process for sharing of information between stakeholders in relation to the Rule 35 process appears to be reliant on systems which contribute to their inefficiency and inflexible nature. In the event that a review of the Rule 35 and adults at risk policy does take place, consideration needs to be given for devising a system which addresses these issues. You're still of that view?
Yes.
you've also recommended, as we've discussed, better training to address all of the limbs of the rule,
Yes.
and to address clearly the thresholds for completing of them.
Yeah, I mean, it's fair to say I don't think that the rules themselves are fundamentally flawed. I don't think that at all. I think it's their execution that's flawed.
And you'd no doubt recommend not just training, but also a system of feedback and oversight about the quality of reports that are being created.
Absolutely. You know, life evolves and healthcare evolves. So, you know, I can imagine that even if a significant amount of work was done to correct a system which has been unaddressed for a considerable period of time, even if those measures were put in place, we will still learn. You know, things will change, the environment will change, or the detained persons may change. So we would need to, you know, reflect those changes as we go forwards in terms of the oversight, in terms of the policies and how we execute them.
Yes, and to ensure that they're just operating adequately in terms of the quality of what's being done.
Yes.
At page 60 of your supplemental report, you make a recommendation, or suggest a recommendation in relation to, it's noted as Rule 35.1, but I think given the context of the paragraph refers to victims of torture, that may simply be a typo and you're actually talking about Rule 35.3. Is that right, in page 60 of your supplemental report?
Take me to the point there.
So you say you recommend a change to has deteriorated instead of assessing the likely impact of detention, and you refer to the context of evidence of torture.
So I think, if I'm not mistaken, this is in the original report, because I think...
So I may be,
Yeah.
you may be right.
Is it?
Let me look.
I think when I reread this... No, supplemental report. Just remind me which page is that? 60?
I think it was page 60, but actually it may be
I don't think
page
it is.
59.
59, okay.
Well, perhaps I can just ask you about the substance of the
Yeah,
the
I
question.
I think, and I don't think I've made the point particularly well when I reread this. This is to do with the ability to predict. So I don't think that I'm recommending that it should be changed to that.
No, I see.
Do you see what I'm
That's
saying?
what I wanted to ask you about.
Yeah, no, I'm not. I'm not saying that. It is.
It's
it
just
is,
easier to identify when something has deteriorated,
Absolutely.
as to opposed to
Than
the
to
impact of
predict it.
detention on
yes,
deterioration.
than to predict it. Absolutely.
I see.
Yeah.
So you're certainly not advocating a wait-and-see approach for harm to
Absolutely
eventuate.
not. No.
And you agree that the rules should be precautionary in relation to all of the limbs?
Preemptive, definitely.
I'm grateful. If we move on then to mental capacity, at page 67 of your supplemental report, you say that those who lack capacity to make decisions should not be overlooked, and that they may self-neglect and they may have raised associated risks of suicide or serious harm. Would you agree that people who may lack capacity may also be unable to advocate for themselves?
Yes.
They may be unable to make decisions to engage with healthcare,
Yes.
and they may be unable to attend medical appointments,
Of course. Yes.
or to raise concerns about their treatment in detention.
Indeed.
It's therefore important in relation to those people then for healthcare to be proactive in identifying their needs, isn't it?
And assessing capacity.
Yes, and identifying any health concerns.
Or lack of capacity in relation to specific decisions.
Yes. D1275, who we briefly mentioned this morning, is someone who lacked capacity to make decisions about his medical treatment, the conditions of detention, or to instruct a solicitor. He was identified by wing officers, by detention staff, as requiring a mental health assessment. but that he may lack the capacity to attend appointments and to engage with healthcare. He missed 13 appointments and was discharged from the mental health caseload on 3 occasions. There doesn't appear to have been any visit to the wing to see him, to assess him, or to find out why he failed to attend so many appointments. He continued to be referred back to the mental health team but was discharged. Sandra Calver gave evidence that there is an assumption that it's the choice of the individual whether to attend a medical appointment or not. Would you agree with that generally?
Yes, autonomy is important in an adult. You're assuming that they have mental capacity.
Yes. But on this occasion, she accepted there doesn't appear to have been any consideration of capacity as there should have been in the circumstances. Would you agree with that?
I would agree with that.
And that's, again, of quite serious concern, isn't it?
Yes.
Where there were missed appointments which related to apparent concerns about his mental health and a need for assessment, there ought to have been a more proactive investigation into the reasons why he'd missed those appointments, oughtn't there?
Even if it was just to test capacity at that time for the reasons for him not attending. So you've reassured yourself clinically that that's been taken care of.
Yes.
Rather than just assuming.
Yes. As it turns out, D1275 was suffering from a schizoaffective disorder with some psychotic symptoms, and he was hospitalised in an inpatient psychiatric unit shortly after he was released from detention.
Yep.
And despite concerns about his capacity being raised by the detention staff on the wing, no mental capacity assessment was carried out by healthcare until after his lawyers obtained an independent report. It should have been, shouldn't it?
Yes.
He was also, we now know, being used as a guinea pig for spice, for drugs, and no concerns were raised by healthcare about his safety in detention or his vulnerability to exploitation in that way. And he suffered spice attacks several times whilst he was in Brook House. There was no provision within the IRC at the time to provide him with access to independent advocacy to assist him to access healthcare and his legal rights. Do you think that there should be such assistance in IRCs?
That's a good question. I mean, I think I would have hoped that the healthcare were those advocates. You know, I think that's how I would have viewed their role.
Yes. Is there a role in addition for independent advocacy on the part of a detainee, given healthcare clearly have other considerations applying to their role?
It's a good question, and I've wrestled with this in my own mind, because what one doesn't want to do is create an even more complex system where there are more silos and more barriers and hurdles to overcome. I think what is needed is more expertise, but it needs to be done in an integrated fashion, as I've kind of alluded to, whether it be within the Home Office or within the healthcare or both, but done in a way that it's addresses or is able to be utilised in a way which addresses the sharing of information aspects that we discussed earlier. But it's got to be integrated. It's got to be confluent.
Yes. The danger with someone like D1275 is that he wasn't presenting as being unusual or disruptive or indeed overtly dangerous to self-harm or suicide. He effectively withdrew, and although he was deteriorating, he clearly fell through the healthcare net. And so the concern is that he hadn't reached that sort of threshold where healthcare were going to be concerned about him, and that's where potentially an independent advocacy service would have assisted him. Do you have any comment on that?
Yeah, it's really difficult for me to make a decision about something like that at this moment. I guess I'm also aware of the fact, like you say, that the attention of the healthcare would have been deflected elsewhere, undoubtedly, with respect to, as you say, the ongoing use of psychoactive substances and the use of force and other things that were probably diverting them away. So it did, as a result of these other things that we've talked about, these other failures, the attempt to manage complex people in this environment, you're then not able to address more wholly the needs of your population.
Yes.
So somebody like that would be more likely. So I still go back to the notion, I suppose, ultimately, that if you weren't deflected away or diverted away by, or magnetised, polarised towards people who were perhaps drawing particular attention to themselves, one form or another, and I don't mean that disrespectfully, that you're then not able to look out for those other people who aren't able
Yes.
to advocate for themselves.
And they do, as he does, seem
Yeah.
to have done, fall through a gap.
Yeah, sure.
So if it's not happening in healthcare, it needs to be happening in some other form.
Yeah, I still think healthcare should be responsible. I can't get away from that. I mean, I think, I certainly see that from the prison side of things.
Yes.
In my experience, you have to take care of everybody.
One thing that independent advocacy could provide over and above even what healthcare could provide if doing their jobs properly, advocating for their patients, is assistance with their detention decisions, in other words, their immigration cases, which again, they may lack capacity to make decisions about. That
Yeah.
wouldn't be a healthcare role, would it?
No, it wouldn't, and I think that's fair. Yes, you would want to avoid that further complication of the dual responsibility.
And avoid the gap that it
Yes, yeah,
gives in terms of those who lack capacity to deal with their detention decisions.
yeah.
That gap seems to have contributed to the harm that was caused to D1275, because he continued to deteriorate in detention whilst he lacked capacity to deal both with his treatment and attendance at medical appointments and
Yeah.
also his immigration case.
Yeah.
The Home Office in July 2020 introduced a DSO 04 of 2020 entitled Mental Vulnerability and Immigration Detention to give guidance to ensure that the necessary support is offered to those who lack decision-making capacity. Theresa Schleicher from Medical Justice gave some evidence that the introduction of this DSO doesn't address the concerns about those who may lack mental capacity in detention, because it makes no provision for the gap that has specifically been identified as the need for independent advocacy. She said that Medical Justice continue to see people in detention, including at Brook House even in the last few months, who lack capacity and who are not swiftly identified and assessed, and who, even if they are assessed, there's no provision made for them. If that's right, that continues to be a concern, doesn't it?
Yes.
I want to check the time. That might, just ever so slightly early, be a good point to pause for a break. Can we say
Thank you.
15 minutes? So maybe 25 past.
Thank you very much.
Thank
you,
you.
Doctor.
Doctor, I now want to look briefly at segregation and the use of E-wing. We heard from Sandra Calver that use of force was used to relocate people from the residential wings to E-wing, including on vulnerable people who were at risk of self-harm. Is that your understanding as well?
Yes.
Could we look then at the case of D2159? His medical record is at CJS 007001, and we can show that on the screen in relation to the 5th of April. Sorry, 7001. So 2 zeros, 7001. There we go. Fantastic. So we see from the 5th of April entry that he appeared unwell and he was on food and fluid refusal. He appeared to be urinating on the floor, and the plan was for an ACDT, and the nurse had expressed their concerns. The next entry on the same day notes that he had visited the detainee at 11:50. He was still uncommunicative. He had managed to carry out a blood pressure, which was 104/76, and a pulse of 55. He hadn't allowed any further observations to be taken of him physically, such as blood sugar, temperature, or oxygen saturations. And the room smelled, and it appeared that the detainee had been incontinent of urine on the floor. He asked an officer to find someone who can clean the floor at least to make it smell better, and noted this nurse is quite concerned over the detainee and his general welfare, have asked if a psychiatrist ought to assess him. It was clear that he was unwell, and a decision was taken by the clinical lead, Chrissy Williams, whose entry we see underneath that of Mr. Little's on the 5th of April, that he should be moved to E-wing in his own interest so he could be observed closely. And it appeared he hadn't showered, and self-neglect was noted. That decision also contained the note, restraints may be used, and that a doctor will review to continue each day with advance directive. There's nothing in the entry to indicate that the clinical lead, Nurse Williams, spoke to D2159 about relocating him for his own protection. Do you agree?
I agree.
Chrissy Williams gave evidence that she couldn't recall if she spoke to him about the reasons for his move, but she agreed she should have done. And she said that by restraints may be used, she meant holding his hand to persuade him to come. Restraints may be used doesn't really convey holding his hand, does it?
No.
It indicates either a use of force on him, a restraint,
Yes.
or indeed the use of restraints such as handcuffs.
Yes.
Is that what you would understand
Absolutely,
by that
yes.
entry?
Yes, I would.
As a consequence of the nurse's recommendation, a planned use of force was adopted, and we know that because we have the use of force form for that date, which at page 2 says it was a planned use of force to prevent self-harm. He was put in an inverted wrist hold, an arm hold or lock, and he was handcuffed for 5 minutes. And again, we know that from the use of force form at page 3. It was a 4-person control and restraint in full PPE, including the use of a shield. And at one point, he appeared to be resisting because he dropped to his knees, but that could also have been because he was too weak from food and fluid refusal, couldn't it?
As evidenced in part by his low blood pressure.
Yes. Mr. Collier, the inquiry's use of force expert, has looked at this incident, and he criticises the use of force on someone in such a condition due to food and fluid refusal as being unnecessary and disproportionate to the risk that he presented. He particularly says that the use of the shield was unnecessary, handcuffs were not appropriate, full PPE was unnecessary, and again referred to his physical condition as meaning that he presented very little risk to staff, and therefore the use of force was disproportionate. In this case, the reason force seems to have been used, again, was because healthcare recommended or at least approved it, doesn't it?
Yes.
His condition as a result of food and fluid refusal doesn't appear to have been taken into account by those making the decision to use force, does it?
Nor his capacity, mental capacity.
Indeed, nor his mental capacity. This wasn't a case where a Rule 35.1 or Rule 35.2 report was done. Should they have been?
Certainly, Rule 35.1, Rule 35.2, he's not at this point in time indicated that he's about to self-harm, but on the basis of the neglect and the food and fluid apparent refusal aspect of it, and we don't know at this stage from the information I've been given whether that was intentional or unintentional. Because of the lack of capacity, it could be unintentional food and fluid refusal.
Yes.
I would say yes, a Rule 35.2 should have been considered.
No mental health assessment was done. It should have been, shouldn't it?
Yes, yeah.
Chrissy Williams accepted in her evidence that the use of force was wrong and that she should have raised concerns about a use of force prior to it being done. Would you agree with that?
Yes, and I just question, it's not something that would ordinarily, I would expect to come across from a nurse unless asked. So can we use of force? Would we need to use of force? The whole justification thing is not clearly explained at all, let alone the sanctioning of it.
Yes. And would you agree that in all those respects we've just been through, there was a series of failures in the safeguards which led to him being abused and ill-treated?
Yes.
In particular, by a use of force that was unnecessary and excessive?
And yes, disproportionate, yes.
In relation to D1527, we considered his case before the break in relation to the incident and in relation to Joe Buss, but he was also a person who was managed on E-Wing under constant watch on an ACDT, wasn't he?
Yes.
He's another illustration of the use of segregation in relation to managing self-harm, suicidal ideation and mental ill health.
Yes.
Dr. Bingham's view was that in his case it was an inappropriate means of managing his distress and the symptoms of mental health problems and self-harm. Do you agree?
Yes. Yes.
Again, it seems to be that segregation is what's done. Recourse is taken to segregation not as a last resort, but as a first resort, effectively.
I don't know about a first resort, but it just seems to be the custom and practice in place that is what we will do next.
Yes, because they don't know what else to do.
Yes, or that they have any other mechanisms, apparently.
But in the absence of the use of Rule 35.
Yes, or a healthcare unit where somebody can be more closely observed. Although I've heard the evidence that even somebody on constant supervision could still, access other parts of the immigration removal centre, so thereby not segregating them excessively. I'm not sure I've seen the evidence that shows that was done consistently for all of the people that were ever located in that unit.
Yes. That's particularly of concern because, as we've touched upon previously, segregation and isolation are factors that exacerbate mental health problems in some cases.
In some cases, definitely.
And they can cause deterioration in many mental health conditions, including those that we see as prevalent in IRCs such as PTSD, depression, anxiety.
Yes.
Is that right?
Yes.
And they are associated, that is, segregation and isolation are factors associated with increased thoughts of self-harm and thoughts of suicide related to an environment that's socially isolating. Would you agree with that?
Yes, it's devoid of stimulation.
So what is being carried out as a response to those types of underlying conditions and incidents of self-harm actually exacerbates that behaviour. Is that your understanding?
I would feel there is a high level of risk of that, yes, absolutely.
Dr. Bingham said that in evidence that what's really needed instead is de-escalation and a therapeutic intervention. Would you agree?
Absolutely, yes.
She gave evidence again that if someone is so unwell as to need to be segregated, that suggests that they really shouldn't be in detention in the first place.
Yes, I think certainly that's where the Rule 35 should kick in, so that you're notifying the Home Office that this is a measure that you've had to take because of that deterioration. And while that review of detention is taking place, it may be that for that hopefully short period of time that may be necessary, and I can't disagree with that because they don't have any other options, but it certainly doesn't seem to be the process that was followed. So in other words, that that use then became in its own way extended and overutilised.
Yes, causing harm.
Causing harm, yes.
Healthcare staff in D1527's case, Dr. Bingham thought should have been raising concerns and contraindications to the use of segregation for him. Do you agree?
Yeah, I think so, yeah.
In relation to food and fluid refusal, again, D1527's case is an example of someone with underlying mental health and self-harm issues going through some lengthy periods of food and fluid refusal. Have you seen that from the records?
Yes, yes.
We've heard that there may have been a tendency not really to explore the reasons for food and fluid refusal in Brook House at the time, and that observations were effectively primarily based upon basic physical observations.
Yeah.
Is that your understanding?
Yes, where the detainee consented to those observations.
Yes. It was often assumed that food and fluid refusal was a protest or attention-seeking behaviour. Did you see evidence of that?
Certainly, yes.
It wasn't particularly clinically investigated in terms of exploring the underlying reasons or causes.
No, it wasn't.
It could be a sign of distress.
Could be, yes.
There can be possible psychological causes for food and fluid refusal.
And organic causes, yes.
And depending upon the cause, it may require a different response.
Yes.
It generally wasn't considered in conjunction with a risk of self-harm, was it?
No, it wasn't.
It should have been, do you think?
Yes.
It didn't seem to also be connected to consideration of the adults at risk policy, did it?
No.
Again, there seemed to be a disconnect there. Or indeed, with Rule 35, food and fluid refusal wasn't leading to a consideration of Rule 35.1 or Rule 35.2 reports.
It wasn't.
So again, a disconnect. It should have been considered, shouldn't it?
Yes, it should.
In D1527's case, his repeated and prolonged periods of food and fluid refusal should have prompted consideration of a Rule 35.1 report, in your view.
Yes. And that may have needed to have been on a repeated basis.
Yes, at each stage,
Yeah.
and with ongoing review.
Yeah.
You say at paragraph 4.7.5 at page 50 of your supplemental report, within the case study for D1527, there was an extended period of apparent food refusal which was also managed under the ACDT process. In my opinion, the material provided demonstrated a deterioration in D1527's mental health following the Rule 35.3 report and the subsequent response from the Home Office stating that detention was being maintained. It's not clear from this case as to the reason why there was no further escalation to review or provide a Rule 35.1 or Rule 35.2 report to notify the Home Office of D1527's further issues following this decision. It's possible to speculate that as a consequence of the fact that where there was a response to the Rule 35 from the Home Office stated that D1527 was on an open ACDT and that he was on treatment for depression, that the healthcare staff felt there would be no rationale for re-presenting further information to the Home Office despite the apparent deterioration. Nevertheless, they should have done, shouldn't they?
Yes, yeah.
This case highlights the concern that there was no appropriate and dynamic approach to the use of the Rule 35 system, given that despite D1527's prolonged food and fluid refusal, as these concerns were not relayed to the Home Office. So there also doesn't seem to have been any consideration of his capacity, does there?
No.
And there doesn't routinely seem to have been consideration of a person's capacity in relation to food and fluid refusal cases.
Certainly not documented.
No. You would expect that if a capacity assessment had been done, it would be documented, wouldn't you?
Yeah, absolutely. Yeah.
That should routinely have been happening, shouldn't it, in cases of food and fluid refusal?
Yes.
Moving on, I just want to deal with some of the further recommendations that you made in your report, please. You say in your original report at paragraph 6.5.16 and also in your supplemental report at pages 61 to 62 that independent medical assessors may be a route for the Home Office to gain clinical input and assistance in relation to these types of decisions. Is that right?
Yes.
In your original report, you suggested that a system for providing the support of independent medical advisors within the Home Office could be used to consider medical issues prior to detention, and you mentioned that this morning.
Yes.
Is that right?
Yep.
You also recommended at page 62 of your supplemental report that it would be helpful for the Home Office to review information prior to arriving in detention so as to make decisions as to detention about adults at risk. Is
Yes.
that right?
Yes.
So this proposal, primarily its purpose, is to ensure that potentially at-risk people are screened out sooner rather than later. Is that right?
Screened out meaning not coming to detention in
Yes,
the first place.
exactly.
Yes.
Screened out
Yes.
of the entire process.
Yes. Yes.
So that they don't come into detention at all.
Yes.
And so aren't exposed to the likely harm that vulnerable people experience in detention.
Indeed.
Effectively so that they're not exposed to any risk posed by detention.
Indeed.
Once someone is in detention, though, is there a role for independent medical advisors at the Home Office in that situation?
I think the key here is, and the analogy I think I may have mentioned in one of the reports, is around something like the DVLA where they have medical advisors. So as a GP, if I'm not sure about somebody's fitness to drive, I can contact another doctor and speak to them about that, who that doctor has the expertise and understanding around fitness to drive and the medical conditions impact upon that, whether that person is still driving or needs to regain their licence. And I think the value of having medical advisors within the Home Office, albeit independent, because we are, as doctors, have to uphold our own independence generally. I can see the conflict there around, being the voice of the Home Office, but you're speaking doctor to doctor. Clinician to clinician, I think, has a lot of weight to it and adds something to the whole system there, or could add something to the system there, so that you're challenging back to say, this doesn't have enough information, or what did you mean by this? Can you provide more information, or can you provide an update in relation to the information that you've sent through?
Yes. You'd accept it's important for doctors and indeed healthcare staff to review a person's presentation over time. Indeed, that's been one of the criticisms you've had, that
Yes.
there's no system for doing that.
No.
Would it be challenging for a clinician who has no clinical involvement with the detainee to be able to keep his presentation under review once someone's in detention, or would you view that still the doctor in the IRC would still be fulfilling that role?
What do you mean by that? Sorry.
So if you're talking about independent medical advisors in the
independent.
Home Office,
Well, I think if you're being provided with the information on a regular basis that says these are the people that from an IRC side, these are the people we are concerned about or most concerned about because of all of the things we've discussed today, whether it's the ACDT, food and fluid refusal, history of torture, significant mental health issues, whatever they may be, or deterioration, then you can track that and you can follow it. Ultimately, I would argue it's the responsibility of the healthcare provider to be doing that, and those GPs essentially are leading that process, or should be leading that process. But then you've got the interaction with that, if you like, the equivalent in terms of line management at the Home Office to say, where are we with this, or this has now changed. Does this affect your view on ongoing detention?
Yes, and because, of course, independent medical advisors at the Home Office would still be reliant upon that third-party information from the IRC, wouldn't they? Yeah. So that side of things would have to be working effectively.
It would, but I think in a way, I guess, if the system was working if the system had been working effectively, you wouldn't need those medical advisors within the Home Office. And I think certainly to begin with, until the system was working effectively, that could be an essential component of ensuring that quality and the consistency and the uptake of those mechanisms in the correct way.
So it could be effectively some form of quality assurance and oversight.
Yeah. At the moment, we have essentially a system where
there's nothing.
The author is the marker of their own homework.
Yes, I see. So there could be a dual system in place for screening out of people due to independent medical advisors prior to detention, and then a quality assurance and review and oversight mechanism of those independent advisors at the Home Office if someone came to be in detention but might still be considered vulnerable.
Yeah, and I suppose thinking it through pragmatically, if there was a sufficient mechanism in place in order to divert away from detention in the first place, a bit like liaison and diversion happens in relation to people going into prison, and that would be useful. Clearly, I could imagine that the Home Office doesn't necessarily have all of that information in front of them, or, based on what I've seen from the information provided, that need to detain outweighs those factors, then detention has to happen. Then it's what happens after that point that then feeds back into the process to say, okay, we've gathered more information. This is the substance contained within a Rule 35, 1, 2, or 3, or even the Rule 34.
Yes.
All of those mechanisms then kick in properly.
Yes, so it would be a way of ensuring the adequate operating of Rules 34 and 35 under all of the limbs of the rule.
Yes, and I think it also sends a red flag to those people working inside the in the healthcare provider in the immigration removal centre that, we've had to do this. We appreciate there are some risks associated with it, and you need to take additional care there. And I know we've talked about what that means for those people who perhaps slip under the net, but nonetheless, if you're highlighted as to what those risks are at the outset, it puts an additional level of safety around the system.
And that system would also need clearly a proper system for ongoing review and follow-up of those who had been seen.
Yeah. And I mean, that's a very difficult system to configure because, of course, things change very dramatically within, could be hours or days. And I would hesitate to put a time frame on something like that.
It would also be beneficial to formally and systemically link the ACDT system with the completion of Rule 35 1 and 2 reports, wouldn't it?
Yes, it would.
Yes. And indeed to, again, formally and systemically link the food and fluid refusal aspect to the completion of Rule 35 reports under Limbs 1 and 2.
Yes.
You've...
and use of force.
And use of force in relation to particularly self-harm.
Yes.
So finally, Doctor, I'd just like to ask you about some evidence that Dr. Bingham gave, that there's a link between the failure of all of these systems and safeguards and the mistreatment of detainees, and that what she said was it's impossible to really separate these issues. We are talking about failures of safeguards in Rule 35 1, Rule 35.2 and Rule 35.3, Rule 40, which means that vulnerable people are not picked up as vulnerable and they are kept in an environment. And so we are talking about a failure of the safeguards to stop vulnerable people being in this environment. Then we are talking about an environment which has a known negative impact on mental health. So where behaviours like self-harm, like distress, like mental health problems are treated as challenging behaviour, so an inappropriate response that leads to escalating mental health problems, increased risks of self-harm, she said it's a perfect storm, and in that situation we have people that are then unqualified to manage. Their only recourse is to use of force, solitary confinement. They don't have the capacity to do a therapeutic intervention, so the possible responses are going to be inappropriate. I don't think it is possible to separate that from the abuses that we see. Do you have any particular comment upon that view? I mean, what's your view as to the link between these failures and the incidents, the type of incidents of mistreatment that we see captured on Panorama?
I think, yes. I mean, I agree with what Dr. Bingham has said there. And I certainly see that is the apparent practice that seems to have been allowed to grow in this environment.
And to continue.
And to continue. And, you know, at what appears to be significant harm to detained persons who, as you started at the outset, are there on an administrative basis rather than a punitive basis. And we appreciate
and without a time limit.
And without a time limit. And I appreciate that, you know, deprivation of liberty in the prison's case is the punishment, not the deprivation of healthcare. I think what we're seeing here seems to be a deprivation of safeguards that is contributing.
Thank you. Chair, I don't have any further questions for this witness. Do you have any questions?
Thank you very much, Ms Simcock. Thank you, Dr Hard. I do just have one question, just in relation to, obviously, you've got a lot of experience of clinical care in a prison setting, and you talked a little bit about the appropriate setting up of resource to actually provide what is needed in an IRC setting. I'm just interested in your, if you have any reflections on it. From what you've seen of the structure at Brook House, is that akin to the kind of way that healthcare would be set up in a prison, albeit there's no in-bed healthcare? Inpatient.
Yeah. It does seem to be sympathetic to that experience that I've had in prisons, and is prioritised towards that sort of level of need rather than the safeguarding component, as I was trying to say at the beginning, that seems to be more of a footnote, the safeguarding components to the healthcare provision. And as I said, I can see the conflict there. It's something very detailed and involved, like doing a Rule 35.3 report, which would essentially, in my mind, stop you in your tracks. If you discovered that, then what do you do with the rest of your clinic? And I can see how a clinician, a GP working in that environment would feel that's very difficult, or they get a phone call from a nurse on the wing saying somebody's just declared that they're a victim of torture. What are we going to do? And I can see the complexity there. I haven't yet worked out how you would fix that. It's very complicated.
Thank you very much. I have no other questions for you. Thank you very much, Dr Hard. It's been a long day, but it's been very important to hear evidence. I very much appreciate it. Thank you.
Thank you. So 10 o'clock tomorrow we'll hear for Professor Bosworth.
Thank you very much.
Thank you.